and it's reversed, remanded back to me. Judges are supposed to be trained to be impartial and not let any personal feelings or biases or feel offended that they were reversed. You should treat it as like a learning experience. I don't know of any judge that has a perfect affirmance record.
The honeycut motion is only required for the issues that are on appeal and to modify them. So enforcement or modifying issues that are not on appeal doesn't require it.
And the Supreme Court has said, you shouldn't be here on this. Why are they making you do this? Well, that's what the judge said to do. So here I am.
Oh, really?
It's happened.
Good morning, everyone. Welcome to our October 2nd, 2021 session of the Our Nevada Judges Perspective Series. This is Reversed and Remanded Family Law Appeals, Family Law Appeals and Procedures and What to Expect on Remand. I am here in the Worldwide Digital Broadcasting Studios. We have, of course, Alex Falcone and Brittany Falcone back in the back there. We have John of WWDB-TV back in the back monitoring things. Today will be an interactive panel presentation about family law appeals and procedures and what to expect when a case is remanded. I am the new Perspectives Media Director for Our Nevada Judges and your moderator today. I'm a native to Las Vegas. I graduated from UNLV with a mathematics degree in 2006 and then from the Boyd School of Law in 2011. I have been practicing as an attorney for a decade now. I'm a solo practitioner focusing my firm on mostly tenant rights, real estate matters, and consumer protection matters. I am a member of the board of the Clark County Law Foundation, and I am a co-vice president of the Southern Nevada Association of Women Attorneys. Today, we have retired family court judge Cheryl Moss. She served on the bench for 20 years. In 2001, Judge Moss was the first judge to implement problem gambling assessments in domestic relations cases. In November 2018, Judge Moss became the first judge to preside over Nevada's first gambling treatment diversion court. We also have panelist Emily McFarling, who opened a solo law practice in Las Vegas in 2003 with her primary focus of family law. Since that time, she has worked diligently to establish a reputation as a knowledgeable and aggressive attorney, gaining the respect of her peers as well as judges. We also have panelist Marshal Willik with us today. Marshal is the principal of the Willik Law Group, an AB-rated family law firm in Las Vegas, and practices in trial and appellate family law. He has authored many books and articles on family law and retirement benefits issues and was managing editor of the Nevada Family Law Practice Manual. So welcome and good morning to our panelists. Thank you guys so much for being here today.
Good to be here, Alexis.
Thank you for having us.
Good morning.
Morning. All right, so before we get started with our materials, I'll just go over a few housekeeping matters for those in attendance and a few announcements. So for those attorneys who are attending with us by Zoom today, in order to get your 1 hour of general credit, please make sure to leave your bar number in the chat. If there happen to be any attorneys who are viewing on Facebook or YouTube today, it's a little late. So next time, make sure you register right up until the CLE. And we will definitely have more coming. So with all of that, let's get started today. Today we're talking about appeals and getting reversed and remanded. One question, I think, let's just start off with what is an appeal, or maybe more importantly, what isn't an appeal? Marshall, do you want to head up that one?
The people that are asking this question basically don't understand the structure of the court system. Anybody that is unhappy with the final decision made by a district court judge can and usually choose to appeal it to the Nevada Supreme Court. All appeals in the state of Nevada go to the Nevada Supreme Court, and the structure of our court system allows a certain percentage of those cases to be pushed down to the Court of Appeals for resolution. But basically, we have only one appellate stage here. It's not a multi-stage system. And if the appellate court disagrees with the final decision made by the district court judge, they can choose to change it, either altering it directly or reversing for certain changes to be made, and send it back down to the district court for further orders.
So what is the deadline? Like, when do you have to file an appeal of a final judgment from a family court decision?
That's the single most important thing that anybody has to know. It's an absolute fixed deadline, and about the only one that's really critical. You have 30 days from service of written notice of entry of judgment to file your notice of appeal. You blow that deadline, no appeal. You can't overcome that. It is jurisdictional. So that is the most critical thing to know about filing an appeal. If you're unhappy with a resolution at the district court level, you have 30 days and only 30 days to start to do something about it.
Obviously an important deadline. We can have either, maybe Emily, you can answer. Are there any orders, temporary orders or other interlocutory type of orders that can be appealed from family court?
So there's two different types of appeal processes, the normal appeal process, which is the notice of appeal, and a writ. So talking about the normal notice of appeal process, you cannot directly appeal temporary orders, but errors made in temporary orders can get kind of, wrapped into a final decision on the final orders in an appeal of final orders. So you don't address them directly, but they can get reviewed and looked at as part of the final appeal process.
Is there a way to challenge some of those intermediary type of orders that happen while a case is pending?
There is. And I mean, this is the difficulty in family law because we have a ton of temporary orders, so many temporary orders that can go on for a long time. And our appeal rules don't address them perfectly because you either have this final appeal at the end, which, doesn't help if it takes 2 years to get a final custody decision. 2 years of your child's life has gone on during that time. But you can file a writ of mandamus or a writ of prohibition. It's called extraordinary relief, right? It's something that allows you to go directly up to the Supreme Court and ask for relief right then. It's a much more streamlined process. They don't get into as in-depth analysis. It's more, they look at, is this something that's just that we need to weigh in right now?
So the deference on appeal when there's a writ petition filed is probably less, or I don't want to say less, it's more deferential to the district court, I would imagine at that time, yes?
Extremely deferential to the district court. It really needs to be an error that requires the appellate court to jump in and do something right now, that there isn't another remedy in the normal course.
I would add that in real life, I've had, when I sat 20 years on the bench, that I've had writs filed on me, mainly in the child custody cases. And the Supreme Court does resolve those writs pretty timely. Sometimes I had a decision back in 48 hours when they filed the writ, but if there was some time waiting, there are a lot of factors that go into whether or not, the order typically remains in effect. But if there's something of an emergency nature, or there's an actual, very contested dispute, I think the court has some discretion on whether to, pass off the hearing, or once the writ's filed, I assume that the order is still valid and it's still effective. But a judge would have to maybe use a little bit of discretion, maybe in the best interest of the children, any kind of emergency type nature. I think I would look at that and see if any further action would be taken. But typically I would pause, and I know that I could get a result from the Supreme Court within a matter of days. So that's what happens in real life.
So in the real world, so if there is a writ petition that's filed, then you as a judge might have just said, okay, we're going to keep operating under this order, and then just see maybe in the next few days or week what the Supreme Court might say about this issue.
That's correct, Alexis.
Gotcha. Okay. So there are a couple of different types of writs that can be filed, right? There's more than one. Can someone maybe chime in on that?
Yeah, I don't think we need to get it too much into the difference between writs of mandamus and writs of prohibition. Essentially, you should think of writs as a procedure for getting a superior court, the appellate court, to say that a court either did not do something it was required to do as a matter of the court's jurisdiction, or did something that's not allowed to do as a matter of the court's jurisdiction. If your only complaint is that the court is doing it and doing it badly, or doing it and doing it wrong, they will say basically, our intervention by way of extraordinary writ is not required at this time. If you're unhappy with the final result, file an appeal.
Excellent. Are there orders, I guess contempt of court orders do sometimes happen while a case is pending? Are those orders ones that can be appealed?
They generally they can be handled through a writ process. contempt orders when it's something that, obviously needs to be handled right away, or else it's, moot down the line.
Judge Moss, how often are you?
General answer is no, you can't appeal a contempt order.
The exception, which is kind of fun and of special interest to Judge Moss, is in the infamous Vail case, which she presided over for something like 15 years and went up on appeal, 4 times at least that we know of. In Vail number 3, the appellate court ruled that the court can rule in an appeal on an issue of contempt as long as the case is already in the appellate court because of a legitimate appeal in some other question. So if a contempt issue is part and parcel of the orders that were entered, it can be resolved in an appeal as long as the appeal is otherwise generally taken.
I agree with you, Marshall. That's exactly what happened.
Very limited basis there for reasons to go up about a contempt order. Understood. Cases involving child custody sort of often go into the post-judgment phase. Can you guys tell us, and each one of you in turn, tell us what you would like about special orders after judgment and how post-judgment orders are appealed?
So the rule for custody appeals, post-decree custody modifications actually has its own special rule. So they are independently appealable by a separate rule, whereas these special orders after judgment, it's a different rule, and those are like attorney's fees orders or things like that. So the custody orders, when you go into modify custody, those final orders modifying custody are independently appealable under a specific rule.
Yeah, Marshall, do you want to have anything to add to that one?
Yeah, you really asked 2 different questions. Basically, any final child custody determination is appealable. A temporary child custody order during the pendency of the case normally would not be. And a modification of child custody constitutes what Emily was talking about as a special order after final judgment, meaning that the order in question affects the rights of the parties growing out of the final judgment, which is independently appealable in the Nevada Supreme Court. There is a procedure you should probably note right here, something called fast track child custody appeals. It, at least for the moment, exists as an alternate route through the Supreme Court, a allegedly expedited route, although it can still take a year to get through. And if anybody wants to see the fast track rules for strictly child custody appeals, they are posted on the published works page of my firm website, which is willicklawgroup.com, attached to one of my CLEs on appellate procedure, which are posted there.
Thank you for that. Judge Moss?
Yeah, I've had that with they appeal the child custody type order, and then the separate, Emily was talking about with the attorney's fees, with the special judgment order, the court can entertain that independently.
So what role, now we have the Court of Appeals that has come in to the state of Nevada. What role does the Court of Appeals play in family court appeals?
Well, first of all, I think I had to learn what was the acronym, Marshall? The COA didn't sound too well. So it was the.
They didn't like ICA for Intermediate Court of Appeals. They like Court of Appeals, COA.
COA. So the COA does entertain child custody appeals. They are assigned by the Supreme Court. So it depends on the issue. If it's a super important issue, I think the Supreme Court would retain it, such as issues of first impression or something of a greater magnitude. But other types of appeals where it goes on the best interest of the child factors, did the court abuse its discretion in applying the factors, something like that, they think that the Court of Appeals can handle. They do handle those types of appeals. I think they're assigned from the Supreme Court, and the Supreme Court reserves itself for major issues. I don't know if Marshall or Emily agree. That's my impression.
And how it handles, how it works logistically is that early on in the appeal, the appellant, is asked, where should this case get routed? Their answer obviously isn't determinative, but they'll say, yes, that's a family law matter, so it should go to the Court of Appeals. or it's a custody matter, but it's of public, a matter of public policy, something like that. And then the Nevada Supreme Court makes a determination as to where it should get routed. And once briefing has finished in the case, so once the last brief is filed, then you'll get a notice that it's being transferred to the Court of Appeals if it's a case that's going to be transferred there, or else it just stays. You don't get a notice that it's staying, it just stays. So that's the point that it gets transferred, is after all the briefing.
And then if it stays, then at that point, the Supreme Court would either set it for argument or issue its own decision at that point, right?
Yes. And if you get the notice of transfer to Court of Appeals, the same thing. You'd either get a notice, there's going to be oral arguments, or a decision eventually.
Gotcha. What cases is the Supreme Court presumed to hold on to the power over?
Under the Supreme Court rules, virtually every case that you'll conceptualize as error correction will be pushed down to the Court of Appeals. The Supreme Court will keep termination of parental rights cases, 432B abuse and neglect cases, and any case which the court considers to be an issue of first impression, resolving a matter of conflict between existing courts, or resolving a major constitutional issue, will be retained in the Supreme Court, because that's the only court that can overrule existing precedent or set new areas of law in most instances. So they will keep those cases, but virtually every bread and butter the judge got it wrong case, they will tend to push down to the Court of Appeals.
And that makes sense. I mean, the Court of Appeals is sort of deciding, it seems as though they're deciding things that are relatively well settled. They can look at it pretty objectively. If for instance, the Yoakum factors for default is very well settled. So if it's not followed, this appeals court can make that decision fairly easily. That makes sense. Emily, why don't you give us just sort of a brief overview of kind of the appeals process. Once you file your notice of appeal, then what happens at that point through to a decision by the Supreme Court?
So you file a notice of appeal in the district court. With it, you file a case appeal statement, which the notice of appeal is, really basic. It just says this is the appeal the order I'm appealing. And then the case appeal statement provides a little bit more detail, but not a ton. Once those are filed, then the district court transmits the file up to the Supreme Court. And at a certain point, it is then docketed in the Supreme Court, and there'll be a notice issued to the parties saying, okay, now you need to move forward. And so there's a deadline for a docketing statement, a deadline to request transcripts for the appellant to do both of those. If both sides have an attorney representing them in the case, then very early on, around that point, then the parties will get a notice that the case has been referred to the settlement program. There is a spot in the case appeal statement for the appellant to say whether or not the case is settlable or not. I don't know if they don't put it in the settlement program if someone says no, because it seems like I say no and they still put it in the settlement program. I haven't audited to see if I've ever had them not do it, but you say no, it's not settlable, or yes, it's settlable. They put it in the settlement program. So you get a notice it's going into the settlement program. About a day later, you get a notice of who the settlement judge is. If one side doesn't have an attorney, then it doesn't go into the settlement program at all. So that this whole set gets skipped. But once it's in the settlement program, the settlement judge will schedule a phone call with the parties to schedule a settlement conference and establish deadlines for when to file a confidential brief for settlement. If the parties reach a settlement in the settlement program, they then can finalize that settlement by dismissing the appeal, doing a memorandum of understanding with the settlement judge. And in most family law cases, which is probably different than like civil or criminal, usually a settlement on an appeal requires further orders in the district court being entered that memorialize that settlement, because you're going to have continuing modification, continuing enforcement. So generally you have to get a stipulation and order entered in the district court as well to settle a family court appeal. If the parties don't settle, then the settlement judge just sends a notice, files a notice with the Supreme Court that says they didn't settle. And soon after that, you get an order saying, okay, let's move on with briefing. And it sets the deadlines. In a fast track appeal, child custody fast track appeal, that would just be the fast track statement filed by the appellant, and then the fast track response filed by the respondent. If it's a regular appeal, not the fast track one, then it would be the appellate's opening brief, the respondent's answering brief, and then a reply brief filed by the appellant. And then once that's done, as I said earlier, if it's going to go to the Court of Appeals, that's the point that you would get a notice saying it's going to the Court of Appeals, not necessarily immediately, but as soon as they've reviewed everything and determined where it should go. And then after that, whether it goes to the Court of Appeals or not, then you either get oral arguments set, and you get a notice saying it's going to be set for oral arguments, and then you get a notice with the date and time of the oral arguments. Otherwise, you just eventually get a decision. And that process can be relatively quick. I had a case recently where I did 2 oral arguments on the same day, and one of them I got the decision like a week later, which was ridiculously fast. And then one took maybe like 4 to 6 months, and it was the same day. So that time period is completely up in the air for how long it takes at that point in time.
And so at that point now, after the judges have come, either be it the appellate court or the Supreme Court have made their decision, now we're at this point where we're reversed, we're vacated, or remanded. Judge Moss, why don't you tell us what it means for a court decision to be reversed and then vacated and then remanded?
I want to backtrack a little. I want to give the family law perspective and the judge's perspective. Once an appeal is filed, judges were taught that once an appeal is filed, you're divested of jurisdiction. And sometimes things come up in child custody cases, in these types of cases. So the judges have to follow the rules strictly. Once you're divested of jurisdiction, you cannot take actions, issue any orders. There is an exception. I don't know the name of the rule. Marshals can quote it. Child emergency jurisdiction. If there's an exception, the judge can step in to protect the safety and well-being and the best interests of a child. But yeah, that's kind of a last resort.
That's the Manley rule for short-term emergency orders for the safety and welfare of a child.
Exactly. But what's the NRAP rule? There's an NRAP rule for that.
It's not so much part of the rule structure, but under the case law, really.
I see. Okay. So once the appeal is filed, the judges can't do anything.
It sounds like if there's a real emergency, then they can come back to the judge and say, hey, we need you to consider this under this particular case law. But otherwise, once we've got this appeal going, the Supreme Court or the Court of Appeals is on it until a decision is made, correct?
Right, but It doesn't mean that you're totally outside the district court. If you have to, if family law is one of those places where things change on the ground. And if the situation on the ground is such that basically the appeal is ridiculous for some reason, because the order should be changed and it seems clear, then you have the ability under a procedure called Honeycutt to go up to first you go to the district court and you say, district court, if these ABC facts were different, would you enter a different order? And the judge says, well, yeah, now that this has happened, I would do that. Then you can go to the Supreme Court and say, would you please send the case back down so the judge can change the order and it may make the appeal go away. And if they agree, they send the case back down and the judge can make a different order. And the appeal sometimes is resolved right there and right then because it no longer makes sense to even go forward with it.
So the practice tip would be to file a Honeycutt motion on an order shortening time, get before the judge. The judge can well, it's not certified, but issue an order saying the court, if this was entertained, this motion was an emergency motion was entertained, I would be more likely to grant it or not grant it. If it's more likely to grant it, then that pronouncement by the trial court would go up to the Supreme Court to let them know if they would lift the stay to temporarily address the issue. But that's correct. The attorney should file a Honeycutt motion, not expect the judge to just issue an order while this appeal is going.
Two other things to point out, especially because family court cases often deal with so many different issues. So if you have a decree of divorce with property issues, alimony, child support, custody, and somebody appeals only one or some of those issues, the other issues, the district court is not divested of jurisdiction on the other issues. So if I file an appeal on custody and someone wants to go in and modify alimony, the district court can absolutely modify alimony if alimony is not on appeal, only custody is. In addition, the district court can always still enforce the order. So if I appeal child support and the other side wants to go in and enforce non-payment of child support, they can still do that even for the order that's on appeal.
Well, my understanding, Emily, was that I would still require the honeycut motion, at least when I was practicing on the bench. That we absolutely, I mean, I took the rule strictly. The Supreme Court's kind of, you know, when they used to go to family law, I mean, the family law judges conference, they would say, once an appeal is filed, you're divested of jurisdiction. So you have to take the formal process, and the better practice, I guess, suggested practice, is to file that honeycut motion and get that pronouncement from Supreme Court to give you the green light to go ahead and have the judge rule on that independent collateral issue.
The honeycut motion is only required for the issues that are on appeal and to modify them. So enforcement or modifying issues that are not on appeal doesn't require it. I mean, you know, if someone wants to go in and include that analysis in there, it doesn't hurt, but it's not required.
Yeah, I agree. Some judges are just awfully gun shy and refuse to hear anything about anything while an appeal is on file. And it's a little bit exasperating. I've had several honeycut motions where I've gone to the Supreme Court and said, well, I don't think I should be here on this, but the judge made me. And the Supreme Court has said, you shouldn't be here on this. Why are they making you do this? Well, you know, that's what the judge said to do. So here I am.
Oh, really?
It's happened.
So I mean, it can be pretty nuanced as to what issues are still down below with the district court judge, and then what issues may actually be on appeal. If you only do a limited appeal, you know, then it can be bifurcated a little bit in that way. And I could see where the district judges would, you know, district court judges, would, well, you know, we want to be cautious rather than, you know, presumptuous, but certainly it's a challenge. Sometimes it sounds like, and making sure to file that motion is probably going to be your, you know, that's your way to the court anyways, is to file a motion to get the court to make a decision either way, right? So, well, I guess we can get back to it. So, yeah, Judge Moss, if you want to tell us just the differences between reversed, vacated, remanded, once we get those decisions from either the appeals court or the Supreme Court.
My understanding is that if a decision I issued, let's say after a hotly contested trial, then that's an appeal. It's appealed. If the decision is reversed, it means it's your order was completely wrong. So it was either like an error of law. And so if it's reversed, it's reversed. If a judgment is vacated, any order, let's say like an attorney's fees order or something, the Supreme Court can vacate that and just completely vacate it. The word remanded means if it's either reversed or vacated and remanded, that means it would go back to me to make either further findings or to actually rule with the guidelines contained in the appellate court decision and say, you have to follow these guidelines or follow these laws, and then properly issue the decision. That's kind of my understanding of that.
Marshall, do you have anything to add to that?
No, the easiest way of conceptualizing it is that when a case is vacated, it's been ripped out of the ground, root and stem, and anything that flowed from it is gone as well. A reversal simply says that they have found an error of law or fact, and for some reason want to do something about it. A case from about 20 years ago, a couple of cases that came out a couple of weeks apart will illustrate the point. In the Gardner case, the Supreme Court reversed and remanded, saying, okay, you got it wrong, Judge, and we want you to do X, Y, Z, go fix it on remand. In the Springer case, which was just a few weeks different than that, they said, well, the judge got it wrong, but we're just going to change the order, and here's the way the order is going to read now. Bang, 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 bang. So there was nothing further for the district court to do. The Supreme Court handled what they thought the final order would be. A remand means that there's got to be further action at the district court level to enforce whatever the appellate court said. And you would think that district court judges don't really have much of a choice, and most of our current family court judges are highly deferential. In the old days, it was a little bit different. There were a few judges that just said, I ain't going to change the order, and that required a second trip up. It's been known to happen. I've had a couple of those.
It just had one. Second trip up, reversed both times.
Oh,
The same thing.
well, so that's now on to a next question. And so if we're reversed and then remanded, and then Judge Marshall alluded a little bit to potentially instructions. So sometimes if you go up twice now, do you think the Supreme Court would then maybe give instructions at that point if there weren't before?
Well, they give instructions anyway, but what they often do if they're a little torqued, it's a little bit of a subtle thing. They can say, okay, we're going to send it back down again, but this time we're going to have a different judge deal with it on remand. That's usually a neon highlighter that says, we don't even want you touching this again, Judge, because you're not following our instructions.
I can neither confirm nor deny if that's happened to me. But yeah, I think, let me just say for the attorneys listening in, practice tip, make sure when you draft the findings, unless the judge writes their own orders, I've written my own trial court decisions. Findings are super important. So if you're the attorney drafting the findings, a lot of times these appeals get remanded back for insufficient findings. And I see that a lot. So that's kind of what I learned over the 20 years. Make sure you have a very, very detailed trial decision.
One of them
are important, of course, because that's what the Supreme Court, the appeals court also look at, right? And if they don't have those, they can't even make a decision, right?
Yeah,
Well, they'll
I
often make a
don't
decision
recommend
reversing.
copying the court minutes into a court order and make it the final decree.
I have
Nothing against my court clerks, though. I mean, they're wonderful, but it's an attorney's responsibility to make sure there's proper findings and application to the law.
Sure. It does seem, I have seen in family court, I don't practice in family law in family court these days, but in the past when I have been a legal assistant and worked in family law cases, I have seen where it seems that the attorneys will say that the minutes are the thing and you have to do that. But it's good to hear from a judge that, no, you really do need to work together and come with actual findings that would make sense rather than just conforming to the minutes.
Minutes have no legal status at all. And if you want an explanation, I've got a legal note on our published, our newsletters page called The Use and Abuse of Court Minutes. You can read that. It'll tell you everything you need to know.
So, not the only one that's experienced, it sounds like. That's good. All right, so when the, I guess after we're back, we've been reversed, we've been remanded. Who is the prevailing party? How's it determined? Marshall, if you want to start on that.
Well, I'm not altogether sure what you mean by that. The prevailing party is the guy who wins. So if you were the appellate and you've got a reversal, you're pretty much defined as the prevailing party. But that term is more used at the district court level for fee assessment than it is on the appellate side. Whether you consider it a win, a loss, or some of each, once the case is remanded, you're back in front of the district court judge, who will then determine prevailing party, not for the appeal, that's not part of the district court's determination, but on the merits and under the case law that's applicable at the district court level. So maybe I misunderstood your question.
No, see, we're just trying to, I mean, really, yeah, who's the winner, in that case. But on a reversal, obviously the prevailing party is the appellant. So does the person getting a reversal and a remand, does that impact awards of attorneys' fees and costs?
Yes, we discussed this a little bit ahead of time, and Judge Marshal, you weren't in on the round robin. Look, attorney's fees for appeals are a very different thing than attorney's fees in general civil litigation or even family court litigation at the district court level. At the district court level, often fees are assessed at the end of the case. In other words, who won, who lost, who was the prevailing party, and therefore who should get fees. It's turned on its head for appeals. The only way really in the real world of getting an order of fees in an appeal is to get them preliminarily before the appeal is even filed or right after it's filed, before it's litigated, by a preliminary award of fees called pendente lite. Here's the setup. If you've gone to court and Judge Moss has made a decision and said for whatever reason, I won and Emily lost and therefore that's the way it is. And Emily says, oh yeah, well, I'm going to appeal. And she goes up. I can apply as the party who prevailed at the district court level back to Judge Moss for a preliminary award of attorney's fees to defend the judicial order on appeal. It's a very narrow opportunity under a case called Griffith, but it gives you the opportunity, especially if you represent the poor person and the party on the other side is the wealthier party, to get a preliminary award, giving you sufficient resources to defend the order you've already got. I hope that makes sense, but it's almost impossible to get awarded attorney's fees on appeal. I've been doing this for 40 years. I've been doing appeals since the 80s, and it's never happened. No matter how egregious the appeal was, I have never been handed attorney's fees for defending a case at the Supreme Court level. And the district court is generally prohibited from awarding attorney's fees upon remand for the time and money that you spent on appeal. So if you're going to get an attorney's fee award, you should do it, if you were the prevailing party at the district court, right at the time the appeal is filed with the pendente lite application.
That was gonna be a question of mine, is whether or not after the remand you could get those fees, but nope, the answer is no. That's good to know.
Generally, no. There's exceptions for everything. We're talking law here. But the short version is no.
There's always an exception.
I think there are some judges, I'm not going to name names, but I think there's some trend with judges where they say, okay, I've made my custody decision. And you know that it's going to be appealed one way or the other, right? And so the judge says attorney's fees are deferred or separated out until the appeal is final. And, I want to get the attorney's take on that. I think attorneys really want the decision, which is what I normally did. I said, submit it. You want a complete decision, submit your attorney's briefs. I will include that or add that as a supplemental order, like a decision on regarding attorney's fees and costs, and certify that as soon as after my big trial decision was written and filed. And then I'll do a separate, because what I do is I do the decision, and then because the parties don't know who's the quote prevailing party in the trial. Once they know, then they submit for their memorandum of fees and costs. And then I usually turn it around. I used to turn around like a week or two and then make that so that you have two final orders, and then they can go ahead and proceed with the appeal if you know that definitely one party is going to appeal it no matter what. So, but there are judges, I think some of them used to just say, well, I'm just going to defer on attorney's fees, separate it out because I think this is going to be appealed, and we'll, I don't want to have to rule on it until the appeal is like final, or resolved and comes back to me. And so I think attorneys didn't like that. And so the trend for me was to make sure I did the final trial decision. They don't know who technically prevailed. Once they kind of know, then they submit their memorandum of fees and costs. And then that is separated out in order. And then the case is closed down, and then they can go proceed with their appeal. So kind of unusual how that would happen after trials.
Emily, have you experienced that either way? Or I guess with this sort of
yeah.
resolution?
Yeah, it is really nice to have those attorney's fees decisions very soon after the main order, so that you can include it in the same appeal or amend your notice of appeal to appeal the fees award too. Because if it's deferred till after the appeal, you then might have to appeal again late. It creates such a huge can of worms if you don't get it all at once. So it's definitely best to have it all right together at the same time, just to make things more streamlined.
I guess the rules really do, I would say, require judges to make those decisions, don't they? Is there something that says they have just discretion to leave that as an issue? The rule is you get to file your motion for fees, and then there should be a decision on that motion, right? Marshall, what do you think?
There's an old saying that on any given day, any given judge will do as he or she damn well pleases. So the short version is that the rules don't require an attorney's fee award. I have had judges simply choose to defer it where they are not sure a fee award is even appropriate, or they're making a ruling that they think is legally questionable. Generally, a fee award follows the substantive orders relating to whatever it is that was in dispute. But remember that attorney's fees are one of the things that are definitionally a special order after final judgment, which are independently appealable. So if you've gone to court and you've got a decision on property and debt and alimony and child custody and all the rest of it, and you've appealed that, and then later the district court judge asks for a memo and enters a fee award, you've got to file a second appeal. The appellate court will normally consolidate the two for resolution. And if they reverse the underlying decision, say, well, custody was wrong or property was wrong or whatever, they will almost always reverse the attorney's fee award as well and remand both for a redetermination going back down. But I agree with Emily that it doesn't make sense usually, in most cases, to reserve the attorney's fee decision because it could set you up for a second appeal where you could have gotten both matters dealt with at the same time. Hopefully, in the general interest of the economy of the parties.
So when a case is reversed or remanded, who is responsible for making sure that it moves forward? Now we're back in the district court. Who is responsible to get it moving again?
Pick somebody.
Yeah, well, so when the decision is filed with the Supreme Court decision, they file it as a remitter with the order attached. The clerk of the court files it. Once the remitter is filed in the D case, our department is alerted to if it's remanded. We set it back on calendar. We call it something generic like status check or remand status check. So we can proceed and do whatever we need to do to follow the remand instructions. But it's normally filed by the clerk of the court as a remitter with the remittitor with the order attached. And that there, I'm not aware of any deadlines, but we act on it quickly. We try to call the attorneys and say, when are you available to come in? And we schedule it.
I've had different judges all handle it all different ways. So just setting the hearing like that is ideal. That's a great way to do it. I've had other judges that have simply issued minute orders or decisions, full written decisions, fixing what they see the errors to be and making the same decision, or issue a scheduling order that just simply sets another trial and reopens discovery. And I've had situations where they've done nothing at all, and after a period of time, I've had to file a motion for orders on remand and actually be the one moving it forward. So there really is no rhyme or reason or predictability on what any given judge is going to do when a case comes back on remand. Certain judges are more inclined to trying to double down on their prior decision, or just get to a point where they can reaffirm that same decision. And then other judges like Judge Moss, are way more open to hearing what's been reversed and why, and actually making a good solid decision when it comes back down. And so it's very different how it's handled in different departments.
With it being different in different departments, what would be the practice tip you might give Marshal to make sure that your case, if you are particularly the prevailing party, gets moved forward in a timely manner?
Well, again, it depends on what you want. Both of the other speakers are entirely correct. It's the Wild West. All the different ways that they have described it could go have happened and happened regularly. There is no rule moderating it. So if you are concerned about doing something and doing it quickly and you're the prevailing party, you wait until the remitter issues. Some people even file the motion before the remitter issues, but it can't be heard until that happens. And then you get a hearing in front of the district court as soon as possible to get done whatever it is you think needs to be done based on the decision of the appellate court. But it really requires a certain measure of expertise of your attorney, because what you do and how you do it depends on what happened and what it is you're trying to get done.
Yeah, bottom line, I think it's the department's responsibility to get it back on calendar. It's kind of embarrassing if an attorney has to chase us down and say, what are you going to do about this? The case is done and over with, but now it's got to come back to you. So we're usually pretty on high alert for that.
That's a great attitude, Judge.
Thank you.
Every judge is like that.
This is probably coming up about our last questions here. So judges, we always want them to be impartial and neutral and not let biases cloud their judgments and follow the rule of law and the guidelines pronounced by the appellate court if a trial court decision is reversed and remanded with instructions. Judge Moss, what has been your experience with cases that are remanded back to you, and how have you handled it?
Well, after 20 years, the longer you've been on the bench, the less phased you are. So if it comes back to you and the Supreme Court says, oh, you were completely wrong, or, you can't have, you can't get emotional about it. It's business. So you just got to get back down to business and follow the rule of law. And kind of like an educational experience. I mean, some of these were legal issues that were just crazy difficult and complex, and it's reversed, remanded back to me. But it is, judges are supposed to be trained to be impartial and neutral and not let any personal feelings or biases or feel offended that they were reversed. You should treat it as like a learning experience. And it's happened. I mean, I don't know of any judge that has a perfect affirmance record. And so if it's reversed and remanded back, you just have to keep plugging away and remain impartial and neutral. And then you face the attorneys in the courtroom, you know, and the Supreme Court told you were completely wrong on that decision. You just have to, you know, handle it and make better findings or follow the instructions of the Supreme Court. So that's how I handle it if I was reversed and had to be remanded. I mean, my first appeal remand I handled was my first year on the bench. It's literally one of my first cases. It was a Marshall and Emily might remember the Rodriguez case on that big alimony issue and fault, you know, divorce, infidelity or whatever can't be a reason to award or deny alimony. And the trial transcript was like 5 huge trial notebooks. And before we had e-filing, it was 5 boxes. I had to go through, read 5 days of trial with Judge Marin, and then, you know, made findings and on that. But I wasn't the one reversed. It was just something I inherited that was assigned to me my first year as a judge. So that was kind of my first experience with handling a remand. It came from another judge's reversal. Yeah.
That had to be quite an experience, having to go through all of that, a case you weren't even involved in, and now you have to decide what the outcome should be based on what happened before. That would be a real challenging thing. I heard both Emily, I think, and Marshall a little bit allude to sometimes, you know, these, it seems that maybe it was Emily, I think, actually, that said, you know, it sort of seems like maybe the judge will just sort of redo the case to get back to the same decision. Is there any way to stop that or prevent it or put a kink in that at all if you think that may be something that's going on? How do you get a better decision if you're on the other side?
The one that I just had recently, I just appealed it again, got it reversed again. We finally got a trial the second time it got reversed on appeal. I don't know, there's certain judges that you come to expect that from a little bit, which is unfortunate.
Marshall, do you have anything to add to that?
Yeah, I mean, look, there's way more complexity and detail than we can possibly get to in the limited amount of time we have here. I would suggest that if anybody wants to have a little bit more background, they can go over to our website, willicklawgroup.com, and there's an appeals page. And they can take a look at what briefs really look like. They can take a look even at oral arguments that we posted there. And you'll find a couple articles there, including one called Preparing to Sail in Uncharted Waters, which I suggest if anybody's contemplating a family law appeal, read it. It gives you the factors and the considerations, and a lot of the stuff we're talking about here is set out in detail. But really what you need to do is find a qualified domestic relations family law appellate practitioner. And there's relatively few in town, probably half a dozen that know their way around the system. And just ask your questions because each one of these questions is different. No guidance we can give in an hour of question and answer can give people a good guide as to whether an appeal is a good idea or what's likely to happen.
Marshall, it sounds like your website is a wealth of resources that would be for parties and practitioners to go to. Well, we're right about 11 o'clock. It has been incredibly wonderful having you all as part of our panel today. We are very, very grateful to have Judge Moss and to have Emily and to have Marshall here in order to be here on a Saturday of all days with us. Thank you guys very much. We will, again, our next perspective series is October 23rd at 10 a.m. We'll be here again. I will be here again in the WWDB TV studio. And we will go ahead and we can sign off our social media channels. And then as soon as we're able to, we'll put the certificate of attendance and course evaluation in the chat for those attorneys that have been with us today for their CLE credit. And then we will, of course, make sure that you guys are recorded. Super grateful to be here today because I am super passionate about pro bono work, access to justice, and educating both attorneys and the public so they can understand their rights and appreciate the law and the court system. And in addition to her judicial duties, Judge Moss volunteered her time to serve as member of the Subcommittee on Legal Issues created by the Governor's Advisory Committee on Problem Gambling. Judge Moss graduated magna cum laude from the George Washington University, Washington, D.C., then attended the Columbus School of Law, and she graduated in the top 25% of her class. She joined the Nevada Bar in 1997, the District of Columbia Bar in 1995, and the Maryland Bar in 1994. Before taking the bench, Judge Moss was in solo practice. She is a member of the Nevada District Judges Association, the International Masters of Gaming Law, the State Bar of Nevada Gaming Law Section, the Clark County Bar Association, and previously served on the Board of Trustees of the Clark County Law Library. Judge Moss is the daughter of late Dr. Rena M. Nora, Chief of Psychiatry of the Las Vegas VAMC and pioneer in treating problem gamblers. Emily's grown her practice over the years and in 2010 gained the credential of Certified Family Law Specialist by the State Bar of Nevada, which is the top family law credential an attorney can obtain. Emily's a fellow of the American Academy of Matrimonial Lawyers and President of the Nevada Chapter, Fellow of the International Academy of Family Lawyers, and an AV Preeminent Rated Attorney by Martindale Hubbell. Emily is a certified parenting coordinator and mediator, and although her primary focus is litigating complex and/or contested divorce and child custody matters in Southern Nevada and Nevada family law appeals. She is particularly knowledgeable in handling appeals, complex property division and financial issues, international custody issues, parental kidnapping, and high conflict custody cases. Marshal is a certified family law specialist as well, a fellow of both the American and International Academies of Matrimonial Lawyers, former chair of the Nevada Bar Family Law Section, and former president of the Nevada chapter of the AAML. So as far as upcoming events, SNAWA and Our Nevada Judges, we partnered together in 2020 for 5 candidate forums, and this year we are partnering together again for a virtual legislative update series, CLE series from November 15th, 2021 through November 18th, 2021. Those will be via Zoom from 12 to 1 p.m. And each day we're going to present panels of legislative senators and assembly people from the legislature who will talk about pieces of legislation that passed and didn't pass and what may come up in the next session. That'll be 1 general credit for each panel, and the registration will be $25 each day, or you can become a SNAWA member for 2022, and that's only $60 and join us for free. SNAWA is also doing the 9th annual Miriam Shearing Award Gala honoring Chief Judge Linda Bell on December 1st, 2021. That will be at 5 p.m. and it will be at the RJC, either indoors or out on the terrace. So we're happy to honor Judge Bell this year. If you want any additional information about how you can either attend or purchase a tribute page in the program, then we're happy to do that via Facebook or at snawa.com. Now, the Clark County Law Foundation, we've got a couple announcements for them as well. Clark County Law Foundation is a 501c3 nonprofit in Nevada, has been here for 28 years. We have the Let Freedom Ring art contest submissions are due on October 11th, 2021. The art contest provides an opportunity for students to learn about our legal system, justice, and get creative and win prizes. This year's theme is Advancing the Rule of Law Now, and participants are encouraged to use their creativity and originality to make a 2-dimensional representation of an art piece that could include a drawing, a painting, a video, photographs, novels, comics, etc., on exploring how the advancement of legal principles is essential to human rights today. And so that's K to 12 students. Everyone is eligible at K to 12, and there will be prizes in categories K through 5, 6 through 8, and 9 through 12. So that can be looked at clarkcountylawfoundation.org. Liberty Bell Award Ceremony. So those awards for those students who participate in our Let Freedom Ring art contest will be presented at the Liberty Bell Award Ceremony. So since 1983, that's on October 28th, 2021 at 3 p.m. by the way. So since 1983, the Let Freedom Ring Committee has been honoring individuals in our community who uphold the rule of law, contribute to good government within our community, and stimulate a sense of civic responsibility. So this year, we are proud to be honoring attorneys Augusta Massey, and John Pyro for their contributions to the legal landscape in Nevada. They'll join other awardees such as Judge Karen Bennett Herron, Ogana Brown, Judge Bell, and her father, Judge Stuart Bell, were honorees. Attorney Connie Ackridge, Justice Cherry, and others. Justice Kadish was an award winner at one point as well. So we're very happy to have these award winners come in. This will be a hybrid event. Our Nevada Judges is helping us with the technical aspects. Thank you guys so much for that. And then we'll also have people attend in person at the historic 5th Street School, where the Clark County Law Foundation was instrumental in having the Liberty Bell installed as part of its major art projects in the downtown area. Last but not least for the Law Foundation, well actually not quite last but least, November 5th is our attorney memorial. So we also partner with the Federal Bar Association and the Clark County Bar Association each year to honor attorneys that have passed in the last year. And this year among the attorneys who have passed are Judge Lloyd George, who was the founder of the Clark County Law Foundation and its Trial by Peers program. As for Trial by Peers, we are making sure to invite parents and legal guardians who have students who are getting in trouble either in or outside of school. You are able to make a submission directly to the Clark County Law Foundation in order to have your children participate in the Trial by Peers programs. In Trial by Peers, our peer counselors who are 12 to 17-year-olds have been trained and are supervised by lawyers and judges, and have been positive peer influences to thousands of other students in situations that involve stealing, fighting, bullying, being out past curfew, drug and alcohol possession, and more over the last 28 years. Students who are referred into the program are held accountable for their actions, and they learn about real-life consequences of continuing down the path they're headed. So we'll make sure that you get to visit clarkcountylawfoundation.org. And for our Nevada Judges, we're having our next Perspective CLE on October 23rd at 10 o'clock. That will be with our Paul Dela, Executive Director of the Nevada Commission on Judicial Discipline. And we'll discuss the commission and how parties and practitioners are implicated vis-a-vis judicial ethics and judicial discipline. Thank you guys very much. Marshal, Emily, Judge, anything else?
Thank you for having me.
Of course, we're so grateful for you to be here today.
Thank you for the invitation.
Thank you.
Thank you.